For judgment, item number 1.
Submission made by, on the submission made on behalf of the learned counsel for the learned amicus curiae.
Yes,
is it?
my lord.
For the appellant, list the matter after the ensuing vacation.
Obliged.
For motion, part 1, item 2 and 3.
Yes,
My lord, there is another order of this single list, my lord. This first, your lordship may turn, my lord, this order of this honorable court, my lord.
see, in this case, there's a contempt petition
Yes.
and a judgment already passed,
Yes,
isn't it?
yes, madam.
So we'll issue notice today
Yes.
and we will look into the maintainability
Yes,
of the instant writ petition will be kept open and to be discussed or looked into in the next court date, isn't it?
Yes.
Who are the counsels for the respondents? The government is represented?
Yes, my lord. 1 to 3.
1 to 3 is duly represented and you are for?
Four. Respondent number 4, my lord.
So you received notice today,
Yes, lord.
okay? And then the maintainability of the instant writ petition will be looked into in the next court date,
Yes,
isn't it? Okay, heard Mr.
SK maybe.
S.K. Mehdi, learned counsel for the petitioner, who has filed the instant writ petition. For issuance of the appropriate writ or order by submitting that as per this court's order dated 19/03/2020, passed in WPC number 148/2019, a joint verification was conducted on 15/09/2022.
21.
2021, with regards to consider with regards to verify the claim of the petitioner for payment of compensation due to the acquisition of his land and damages caused upon his private property by the construction of the approach road within his land by the respondent number.
In writ petition, I review was
In the instant
Four.
writ petition
in the instant
Respondent
written,
number 4.
4,
Respondent
by respondent number 4. The case of the petitioner is that at the time when the joint verification was conducted, the present petitioners, you were present, isn't it? Were not agreeable to the joint verification report.
My lord, it was not as per the High Court order.
And that since it was not as per the High Court's order in the said writ petition. So, accordingly, the instant writ petition has been filed by the petitioners challenging the joint verification report.
My lord, the annexer J, annexer I,
According-
annexer K, annexer A.
Joint verification report enclosed herein. Issue notice to the respondents. Ms. Valentina so-and-so accepts notice on behalf of respondent number 4, while Ms. Vana Isiawe, learned government advocate, accepts notice on behalf of the state respondents number 1, 2, 3. This court, considering the fact that the writ petition is arising out of a decided writ petition, a disposed writ petition number 148/2019, and also considering that there is a contempt petition number 8 of 2022 pending connected to the instant case, the maintainability of the instant writ petition is kept open. Okay, full stop. This is the matter.
On to the 20th of January, my lord, I'm come.
My lord, if the matter can be taken up this week, because this is a matter of maintainability and similar order has already been passed in other WPC, my lord.
This week will be just a few days. It's not possible. Okay.
After
list
vacation,
the-
after vacation.
List the matter immediately after the ensuing vacation on
20, my lord, 20, my lord, 2 January, my lord.
on how?
13th, my lord.
20,
20?
yes, my lord, January, my lord.
Is it okay?
That's too far away, my lord. If
My
it
lord, only
may be the first week of the ensuing holiday, my
They
lord.
will file affidavit in reply, my lord.
No, whether they'll file or not, we look into the maintainability
yes,
first.
yes, ma'am.
Okay, they don't have to file a written objection
Yes,
for
yes,
that.
regarding the mental ability.
On the 13th or 14th, my lord.
Yes, yes, SK Medi, when will you be available?
My lord, if please, my lord, on 20th, my lord, some cases speaks, my lord. I'll come, my lord.
Okay, we'll make it, we can dispose it of, it's on the maintainability first, okay?
Yes,
If it's found maintainable,
Yes,
then you can proceed by filing your counter affidavit
Yes,
if
ma'am.
it's
Yes,
required. And on the maintainability also, if you have any written submission, that's also.
Yes, ma'am.
Okay. Yes. This on 20, okay, 1/20/25, yes.
For admission, item 4.
Item 4, my lord, this, item, my lord, this writ appeal is pending, my lord, in this same issue, my lord.
Okay,
And this other cases fixed on by, yesterday in other court, my lord, on 20, my lord, January, my lord.
okay. Heard Mr. SK Medi, learned counsel for the petitioner, who submits that the writ appeal number 265/2023 is still pending, and therefore pray that this matter be listed on 21/20/25.
My lord, interim order is there, my lord.
Accordingly, as prayed for, list on 20 so-and-so. Meanwhile, interim order passed earlier shall continue till the next date of listing.
Item 5.
Yes,
May it please your lordship, my lord, in this case, the states have filed their counter affidavit stating that the claim of the petitioner has been rejected 3 times. So, my lord, I've
you want to
made a-
file a reply?
I have filed a reply, my lord.
Okay.
And
So pleadings are complete?
the pleadings are complete, yes, ma'am.
Then can we list it for admission hearing?
After vacation, if
Who's
lordship
the,
permits.
who's the counsel for the respondent? Yes, Mr. Okay, we'll list it for admission hearing in the next date then. Okay. Both the learned counsels for the parties are present. And since pleadings are complete, the matter can be listed for admission hearing. Yes, list on. After the vacation?
After vacation, Your Lordship.
Okay, list after the ensuing vacations. Yes.
Obliged. Item 6.
Yes. What is the stage? None appeared or what? Case called out. None appeared for the parties. List after the ensuing vacation.
Item 7.
Yes, my lord. I'm standing on behalf of my senior, F. Lalengela. He's on leg in courtroom 1.
What is the IA about?
There is a delay, my lord. Delay, my lord, 400, my lord. 400, my lord, 85 days delay, my lord. They file objection, my lord, we file additional affidavit.
One solid year, so it will take some time. We'll list it out on same day.
Same dates.
Okay.
On
Mr. S.K. Medi, learned counsel for the applicant is present, while mention is made on behalf of the learned counsel for the opposite party that the learned counsel is on legs in the other court. In view of the above, as prayed for, list on 21/2025.
Item 10.
Yes,
May I please, Your
who's
Lord?
appearing?
Miss Mary, Borough State.
But she's disappeared?
Yes.
My lord, this is a case of seizure of 122 grams of heroin, which is an intermediate quantity. It was seized from the Nala between Chonpui and Zhoutlang locality. Now, the seizing officer had conducted search of the residence of the accused. However, nothing was recovered from the residence of the accused. The seized article, that is tens of cases containing 122 grams, was recovered from the Nala. So in this case, my lord, there is no possession connecting the applicant to the seized article. May I kindly take your lordship to the report of seizure and arrest that is on page 30 to 31. This is the case happening at midnight, the act of seizure and search. Page 30 of my bail petition, my lord. If I may read with your lordship permission.
Yes.
This is the report of the seizing officer to the officer in charge. I have the honor to report that on 30/5/2024 at 12 midnight, I received an information which stated that Zhou Wenpui of Chonpui is strongly suspected to possess some quantity of heroin at his residence. I reduced information in writing and went to reported place. After complying mandatory provisions of law, I conducted search at the residence of the reported person, and we recovered 10 showcases containing suspected heroin at the drain located at the boundary of Chonpui and Zhou Tlang area, which is thrown out from the bathroom by the accused Zhou Wenpui. I then seized 122 grams of yellowish powder suspected heroin kept in 10 showcases, and I arrested its possessor Zhou Wenpui on 31/5/2024 at 1 a.m. This is for your kind favor of further necessary action. Your lordship will see that the first part, the first paragraph, here it says the search was conducted at the residence of the suspected person on 30/5/2024 at 12 midnight. Now, what is the requirement of law is that under section 42, subsection 1 proviso,
Yes, let's see.
section 42 of the Indian PS Act, subclause 1, the second proviso.
Yes, please read.
Provided further that if such officer has reason to believe that a search warrant or authorization cannot be obtained without affording opportunity for the concealment of evidence or facility for the escape of an offender, he may enter and search such building, conveyance, or enclosed place at any time between sunset and sunrise after recording the grounds of his belief. Now, whenever a search is to be conducted between sunset and sunrise, that is after dark, it has to be preceded by recording grounds of belief. Now, my lord, I have taken the grounds of belief as provided under section 42 proviso mentioned herein has not been complied with, even though a grounds of belief was apparently recorded. That is on page 54, my lord.
Yes.
If your lordship will see the second paragraph of the grounds of belief, page 54.
$54.
Yes, my lord. May I read, my lord? Since a search warrant or authorization cannot be obtained without affording opportunity for the concealment of evidence or facility for the escape of an offender, I entered and conducted a search of the suspected house and the person therein on this 31st May 2024 at 12:30 hours. Now again, if I may take your lordship to the report of search and seizure. The first paragraph says that the search was conducted on 30/5/2024 at 12 midnight. It was specifically mentioned as 12 midnight. Now here at page 54, it was mentioned as 12:30.
Half an hour difference.
Yes, it has to be preceded. It has to be preceded before entering the search. Now this is my point. Now my other point is that Possession is the sine qua non for earning a conviction by the prosecution. Now, in this case, possession was not established. Why I am saying this? Because your lordship will see that when my bail application was first rejected by the special court, recording of evidence has not commenced. Now I have filed this bail application after PW number 2 and 3. Evidence has been recorded. That is on page 58 and 59. Prosecution witness number 2 is at page 58 and 59, my lord. Your lordship will see the cross-examination at page 59. I'll read from point number 1. It is a fact that the excise personnel were already present when we reached the residential area of the accused. I cannot say the exact number of excise personnel present at the PO. It is a fact that excise officer did not produce or carry any letter before entering the house of the accused. These are the seizure witness, my lord. It is a fact that excise personnel conducted search of the accused residence. It is a fact that no illicit drugs were recovered inside the residence of the accused as he traveled from his residence. It is a fact that I have not seen the accused throwing out the seized article. Now, the allegation against the applicant here is that he threw out the seized article from his bathroom, my lord. Now, what the seizing officer deposed in his examination before the court is that he had not seen the accused throwing out the
But
seized article.
in chief, he says we heard something being thrown out, isn't
Yes,
it?
they heard something. Now, in the cross-examination,
They did not see, but they heard.
it was midnight and they heard, but it could be anything. Now, they have not seen the applicant throwing out the seized article. So this is what the seizure witness deposed. Now, the evidence of PW number 3 is the same as that of PW number 2. Now, your lordship will see that in as one case, your lordship has granted bail to one of the applicants therein on the grounds that the involvement of the applicant in that seizure of heroin was not prima facie found, unless proof otherwise. Your lordship will see in bail application 59 of 2023. Your lordship will see para 11. This is a case of commercial quantity, my lord. May I read para 11? For the above reasons, this court finds that on considering the contents of the charge sheet and the evidence adduced so far, the involvement of the applicant in the seizure of 311 grams of heroin is prima facie not found unless proof otherwise during trial by the remaining prosecution witnesses. It is also seen that the applicant is a mother of 3 minor children and a permanent resident of Champai. My lord, I have 4 children and they were dependent on me. My detention in custody has caused severe hardship to the family. I have been in custody for more than 5 months now. My detention is no longer required, my lord, by the investigating agency. If your lordship may kindly release me on bail, trial will not be hampered. And to that effect, my lord, I would also like to produce the order of this court in bail application number 28 of 2023, wherein the applicant therein was released on bail since possession was not established. Your lordship will see that at para 12. First, I'll take your lordship to para 12 and para 14. Page 9, para 12, starting from 7 lines from the bottom. I'll just rephrase the law, my lord. Therefore, from the above provision, it may be seen that the source of knowledge and belief has to be taken down by the officer concerned authorized in this behalf in writing, and if he has to enter a building without authorization of warrant, He has to record the grounds of belief before making such entry and search, but he has to send a copy of the same within a period of 72 hours to his immediate superior officer. Now that is the law, and at paragraph 14, my lord. In the present case, it may be seen that the investigating officer prior to proceeding to Siran cannot be said not to have sufficient time to enter the information received by him when it is an ongoing investigation and when he had the time to inform the Waymay of Siran to detain the petitioner. Therefore, having regard to the mandatory nature of the compliance of Section 42 of the Indian PS Act, and at the same time having regard to the fact that no recovery of the alleged heroin was made from the petitioner, I am inclined to grant bail to the petitioner. Now here, in my case also, no recovery was made from the applicant. Now in another case relating to Section 42, my lord, which is at the stage of bail. Your lordship will see 2004, 12 SCC 266. Page 268. Para
Yes, what
7.
does it say?
Here it says compliance with Section 42 is mandatory,
Yes.
and that it is a relevant fact which should have engaged the attention of the court while considering the bail application. Now this can be taken at the time of bail application, my lord. Now, with regard to bail, my lord, bail is the rule. My case is not a commercial quantity. May I remind myself of this judgment, my lord. Jalaluddin versus Union of India. Para 21.
Yes.
4 lines from the top, my lord. When a case is made out for grant of bail, the court should not have any hesitation in granting bail. The allegations of the prosecution may be very serious, but the duty of the court is to consider the case for grant of bail in accordance with the law. Bail is the rule and jail is an exception, is a settled law. Even in a case like the present case here is under UAP Act, where there are stringent conditions for the grant of bail in the relevant statutes. The same rule holds good with only modification that the bail can be granted if the conditions in the statute are satisfied. The rule also means that once a case is made out for the grant of bail,
Yes,
the
it's
court-
okay. We'll read her. Anything else?
My lord, that would be all, my lord.
Yes, Miss Mary.
My lord, I'll first make a reply with regards to Section 42 of the NDNPS Act, my lord. My lord, if I may take your lordship kind attention to one of the statement of the seizing officer, my lord, which is in page number 37A.
Yes.
My lord, with your permission, may I read the second paragraph, my lord? On so and so, I received information from informant around 12 midnight stating that he strongly believed that Zong Wanpui, who is a resident of Zong Pui Veng, possessed heroin at his house. We proceeded towards Zong Pui after I reduced the information information I received in writing. I then arranged witnesses, and we proceeded towards the house of Zong Wanpui. A loud noise we heard below the house around the same time, and our men were sent to investigate the noise.
See, this is a statement of the seizing officer, but I think
Yes.
he has deposed in the court.
And the,
Has he deposed in the court?
He is yet to depose.
Then we'll look at the deposition before the court, not this.
yes, the deposition before the court, that is the,
See, he has deposed as a witness in the court, so,
No, only PW 2 and 3.
no,
That is the season.
only PW number,
okay, so,
He has
37A
to-
is not, he has not deposed?
no, my lord.
He's
My
not a
lord,
seizing
okay,
officer.
I'll take your lordship kind attention to the deposition which is already made in, before the trial court. It's Annexure 5, my lord. Annexure 5, page number 58. This is Arlarin Oma.
Yes.
My lord, paragraph number 2. On 31/5/2024, excise personnel contacted us and stated that they suspected one Zong Wanpui from our locality possessed some contraband drugs in his residence and requested us to witness these steps taken. When the excise personnel and we tried to enter the residence of accused Zong Wanpui, the door was locked from inside, and the duty officer told them to open the door. And from outside, we heard something. No, my lord, what I would like to refer here is that my lord, in the deposition of witness number 3, it's more or less the same with the one that I have read out. So I will not go through the deposition of witness number 3. But what I would like to state here is that, my lord, Section 42 is power of entry, search, seizure, and arrest without warrant or authorization. This is to enter into the residence. So they
Without
did not
warrant.
enter the residence. They just knocked. They just knocked. So there is no violation of Section 42, my lord.
Oh, you're saying they didn't enter?
They did not enter, my lord.
But did
So
they search?
when
I
they,
thought they
when
said to
they,
search.
okay, grounds of belief might be apparently, belatedly, as alleged by my learned friend, be recorded, presuming that it is recorded at a belated stage. They did not enter. They just knocked on the door. It is before the court. It is before the court in the cross-examination that is intact. They just knocked on the door, and it is on evidence that they do not enter the house. So when they knocked the door, they heard a loud noise. And then they went down to the stream that is connected to Zomwampuya's house. And they found the controversies articles, my lord. And some of them were dissolved. And the remaining were taken out from the Nala. And accordingly, later on, the possessor, Zomwampuyo, was arrested. So they do not enter and conduct the search in the residence. So there is no violation of Section 42, my lord. So, my lord, may I take your lordship kind attention to Section 42? Thoroughly, we can read it together, my lord.
On that point, if you look at the cross-examination, the cross-examination nullifies that point of argument. See, 42, if they don't have the time within 42 hours, if they submit their reason of report, I think that can be considered. But if you look
Yes.
at the cross, they search the residence.
They do not search the residence, my lord, because when they heard the loud noise, they went down to the stream.
But what about the cross-examination then, when they admitted?
Point number 3, my lord.
Page 58, 59, then what do we do with the cross-examination? Page 59?
Page 59.
Point number 4?
Yes,
Five.
before entering the house of the accused. Is that before entering the house of the accused, it
Point
does not
number
say
4.
that they,
Point number
It-
4?
point
Page
number
59, 4.
4. Oh, okay.
And
Point
then
number
5.
5.
Okay, so that line of argument, I don't think you
I
can
see, I
press
see.
the point, that point, isn't it? Huh.
Yes.
Anyway, so now
My-
42, the proviso, what about it can be within 42 hours? Anything to do with that?
So, yes, the information was reported to the superior, my lord, within the next day on 31st.
So it's
And my lord, if I may take your lordship, second point is that if I may take your lordship kind attention to Annexure 7, this is the judgment, even though the present petitioner was acquitted in this case. So now we know that due to the stringent laws in the Indian PS, the offender can be protected by the law itself due to technical problem, due to procedural lapse. Now, even though if we go through the judgment and order, my lord, even though he is not, he was not found not guilty and acquitted of the offense under this section, we can know that we can take an infer that, my lord, he have previously have had the NDNPS case. So, in my humble opinion, my
He's
lord,
not a
for
first-time offender, is it? Huh.
Yes, yes. For consideration of the bail, my lord, he seems to be a habitual offender, my lord. It's just that due to procedural lapse, and
If
offender
any.
can be.
Due to procedural lapse, if any. Okay, sir? Okay. Anything else?
That's it, my
That's it?
lord.
My lord, may kindly allow me to produce another citation which
Ah.
it is regarding section 42. State of Punjab versus Balbir Singh,
Okay,
page 321, para 2B. Now, this violation of this section 42,
para?
para 2C, and